Thanks to all the panelists. We have a very few minutes for any comments from the panelists, if they have some compelling comments. And if not, we'll open it up for questions. All right, we just have maybe 5 minutes just to have a good question-answer period. So, Stephen.
I had a question for Jack, and that is about almost 30 years ago now, there was a proposal for a bill in Congress called the Human Life Bill that would have defined a fetus as being a person from the moment of conception on, and would have been an effort by Congress to enforce the 14th Amendment. And I wondered what Jack thinks about that bill and the possible use by Congress of its Section 5 power, not only to protect prenatal life, but also to potentially protect rights in a way that is different from the way the Supreme Court has done.
That is a fabulous question. Let me give you my bottom line, and then we can talk about the specifics. If Roe versus Wade were overturned, then it would seem to me that the Human Life Bill would be a reasonable exercise of Congress's power under Section 5 to protect the rights of persons, not necessarily the rights of citizens because of the Citizenship Clause. Right, but since Roe versus Wade has not yet been overturned, the one thing that Congress can't do in passing Section 5 laws is pass laws which are contrary to Supreme Court precedent, because Supreme Court will strike them down. So, but the larger question you're raising, which is a great question, is it the case that Congress cannot do any interpretation of its own when it passes Reconstruction power? And the answer is yes, of course they can. They can, and here Bernie is also incorrect.
And just to elaborate, in this context, Congress could presumably argue that they were focusing on the protection of the laws, which are guaranteed equally to all persons. Yes, and so if a fetus were a person, the argument about an affirmative right to legal protection that you mentioned would be implicated.
Yep.
Any other comments? Okay, we'll take questions. We have some people on the line here, so please go ahead.
Thank you. Chris Shandeville, Virginia Law. It's a question initially for Professor Amar and then to others on the panel as you'd like to contribute. Professor, you posited, you can correct me if I'm wrong, but seemed to posit that the Constitution, as originally written, is pro-slavery or was pro-slavery. And perhaps it's because I'm only a lowly 1L and have not yet completed common law that I haven't learned that lesson yet. Perhaps it's further down in the syllabus. But based on my limited understanding of, for example, the 3/5 compromise, which, as I understand it, was an attempt by states that did not have slavery to limit the representation of the states that did have slavery, if anything, was an anti-slavery provision. Based on my understanding of that and other parts of the Constitution, I was just wondering if you could help enlighten me as to how the Constitution was indeed pro-slavery, and then I was curious as to whether other members of the panel might have different views.
Thanks. I'm not going to go into it in great detail because it's the subject of many pages in my book, America's Constitution, a biography, but the 3/5 clause is really the key. It basically delivers the entirety of political power very predictably for the entire period until the Civil War into the hands of pro-slavery forces, because extra credit is given for extra slaves. The more slaves you've got that you kidnap across an ocean or you breed or you steal, the more seats you have in the House of Representatives and in the Electoral College. You're from Virginia. For 32 of the first 36 years, the presidency is occupied by a Virginian because not because Virginia has the most free people. Pennsylvania, by 1800, has way more free people and way, way more voters because it has a broader suffrage. But Virginia has more electoral votes because it's got the 3/5. And so the presidency is consistently occupied by a Southerner or a Northern man of Southern sympathies. There's been a single anti-slavery president in all of American history before Abraham Lincoln. If the test of anti-slavery is simply someone who says simply the following two things: slavery is wrong and we should eventually get rid of it, maybe even over 100 years. But before Lincoln, no president ever says so. No cabinet officer, not a single cabinet officer ever says so. And it's because of the 3/5 clause, which is a cancer at the heart of the system that grows and grows and grows. The system is getting increasingly pro-slavery as time goes on, and it breaks in a massive civil war. That's the story that's told in the book. Pro-slavery presidents mean pro-slavery justices, so you get a case like Dred Scott because the Supreme Court is simply malapportioned. The South, which has a third of the free population, has a majority on the Supreme Court because of the malapportionment created by 3/5. Thomas Jefferson, whom you were taught beat John Adams in 1800 because you're a good University of Virginia person, without the extra 3/5, you see, John Adams wins that election. It's the extra, and Northerners know this, Yankees know that. They say Mr. Jefferson is riding into the executive mansion on the backs of his slaves. That's the burden of Gary Will's very interesting book, Negro President. I could go on and on and on, but I won't. Numbers are really important. John Harrison has written about how important the iron numbers are of the Constitution. 2 years, 4 years, 6 years, 3/5 turns out to be a very important number. I'll let you write a lot of the soft promises in the thing if you let me write all the numbers about who's going to control political power in a Constitution.
Thank you. I'm going to turn to the next gentleman in line here because you were up first before these people came on, so go ahead.
Thank you. I was wondering, with regard to privileges or immunities, seeing as the Supreme Court seems to be taking a case this term, McDonald versus City of Chicago, that may potentially address that question. Hypothetically, if they address the privileges or immunities question with regard to incorporation of the Second Amendment, do you think that there is sufficient history and reasoning from an originalist perspective to justify the right to keep and bear arms being a privilege or immunity of U.S. citizenship under the 14th Amendment?
Absolutely, yes.
Stephen, would you like?
Jack Balkin and I both co-signed an amicus brief saying yes, it is a right. It's regulable pursuant to the police power, but there is a right and it is a privilege or immunity in our opinion.
Thank you. Yes.
Jay Schweikert, Harvard Law School. Professor Amar, you mentioned
And
that...
a former student. Nice
Absolutely.
to see you, Jay.
Good to see you, too. You mentioned that this kind of serious originalism in all of its different forms is something that judges really can't do and legislatures can't do, and it's really up to sort of future generations of scholars. Given this somewhat pessimistic view about kind of government institutions, I'm curious about, more specifically, the way that you think what we do as scholars and what we talk about in law reviews, the ways in which that does sort of affect what we sometimes call the real world, or how it affects government actors. Is the best we can do sort of to do a really good job, you know, on the pages of the law review and hope that the snippets they get are good ones, or is there a way that we can maybe transform all this so that we can be less pessimistic? I mean, in what ways is the project that we're undertaking going to translate into the way our country is run?
The answer is slowly, but I promise you, when Steve Calabresi co-founded the Federalist Society, there was a lot less serious originalism than there is now. So actually, that has changed the culture. And over generations, see, you can't generally teach old judges new tricks. And they very much are the products of what they learned in law school, but people now are learning different stuff in law school thanks to serious panelists like my fellow panelists here. So what you can ultimately hope for is it will change ultimately the constitutional conversation, both methodologically and substantively, but you have to wait. And it's going to, if you're, so in the first half of your career, basically, here's what you can look forward to. Basically being ignored, you're not being cited for things you do say, and if you're really lucky in the second half, you'll be cited for stuff you didn't say. And that's success, because at least it means that people are beginning to take seriously, and you're one of many, many people, and you change the constitutional conversation.
Anyone else want to comment on that? John? Okay, thank you.